Welcome to Sakshi TV Special Immigration Show with attorney Ms. Prashanthi Reddy. Please note that Sakshi TV now has 4 immigration shows every week. On Tuesdays with Mr. Loyal Kaviti, on Wednesdays with Prashanthi Reddy in English, on Thursdays with Chand Parvat Neni, and on Fridays with Banu Nindra. Please do not ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, you can definitely log on to their firm, which is Reddy ESQ. So without any further delay, let's welcome Ms. Reddy on our show. Ms. Reddy, welcome back. I hope you're doing well.
I am. Thank you, Shivani.
Yes. So the viewers, I want you to note that this is a continuation of the previous episode. So last time we did talk about the H1B cap FAQs. So this is going to be the continuation. So Ms. Reddy, before we get on to the FAQs, are there any latest immigration updates that we have to know this week?
I think we should just go to the topic directly.
Yes. So my first question is, let's say that's, so this is an FAQ. So that says, am I subjected to travel restrictions while my H1B is pending? So this is a question from one of our viewers. So what do you think, Ms. Reddy?
So with reference to that, when you file for a change of status, if you're filing for a change of status, you must be in the United States when we file the petition, and you should not leave the country until it is approved. So if you leave the country before the petition is approved, then the request for change of status will consider to be abandoned, and you will not then be automatically converted from, say, an F1 to a H1. So instead, your H1 will get approved for consular processing. Then what would happen is you would have to go to the consulate, get the H1 visa, and then come into the country. So this also, if you do this, if you leave the country while your change of status is pending, this could also affect your cap extension. So if you're on work authorization through cap, cap is only for change of status application. So once your case is no longer change of status, that could, your cap extension could be affected as well. So I would be careful if, while traveling, and make sure you contact your attorney before you decide to travel.
Yes. And also, can one include their dependents on their application?
Yeah, definitely. Dependents can be included. So say you're on F1 and you're filing a change of status to a H1, then you would have to include your dependents, in fact, and file a H4 for them. Because if you don't do that and your H1 becomes successful, then what's going to happen is your dependents will no longer be on F2 because you will not be on F1, and you will most probably fall out of status. So since you don't want that to happen, I suggest you include your dependents as well in your application. If you're out of the country, then what you should do is, there's nothing to include, there's no dependents to include while you're out of the country. What you need to do instead is take your dependents with you for a visa, and along with your H1 visa, your dependents will get a H4 visa. So I think, and that way, all of you can travel together to the US and you can stay together. Yes. Another advantage of filing the H4 with your H1 is also both applications get approved simultaneously. If you file the H4 dependent application separately, maybe they come in later, or for whatever reason, for some reason you decide to file it separately, then remember your H4 application will take, by standalone H4 application, takes much longer than the H1 by itself. So it's just something to keep in mind.
Yes. So Ms. Reddy, let's assume that once lottery was selected, once registration was selected in the lottery, and that their H1B petition was also filed, will they have to leave the country or stop working if their OPT has been expired after the April 1st, but before the October 1st, 2023 start date?
So, as of the date of filing your H1, as per the cap rules, if you're on an F1 and you're filing for a change of status, not consular processing, but change of status for a H1, then whatever your status was as of the date of filing, say you'd filed on April 1st, then as of that date, whatever your status was, if you were on OPT, then your status will continue to be on OPT until October 1st, 2023. Unless in the interim your H1 gets denied or you leave the country, so it's no longer a change of status. So unless something happens while your H1 is pending, as per cap rules, whatever your status was as of the date of filing will continue to be your status until October 1st, which is the start date of your H1. So say by October 1st you do not get a H1, then you have to be careful because maybe your H1 is still pending. Maybe you would want to convert to premium processing before October 1st comes by, so that you don't have to go back onto student status. Though you do have a 60 days grace period, if your H1 doesn't get approved by October 1st, or if your H1 gets denied, you have a 60 days grace period to then apply for some other status or go back to an F1. So something to keep in mind. Those cap rules are important to keep in mind.
Yes. So, Ms. Reddy, so can one leave the country after the H1B cap petition is filed and before it's approved?
So it's the same thing. If your petition was filed requesting a change of status, you shouldn't leave the country until that petition is actually approved. If travel becomes unavoidable, then make sure you contact your attorney before you leave, because your change of status will be considered abandoned and your H1B will not automatically take effect on October 1st. So your H1 will get approved, and your cap there'll be a problem for your cap as well. So make sure you don't leave unless if you're requesting for consular processing and you didn't request for a change of status. Some F1 students prefer to do that. Then leaving the country has no effect whatsoever. But if you're filing a change of status, then it will affect that change of status portion of the application. The H1 will get approved, but for consular processing.
Yes. This is one of the FAQs that we have. It says my first year of OPT is expiring after April 1st, but before October 1st, and I'm eligible to file a STEM extension. Should I file for the STEM extension before April 1st of 2023?
Well, that really depends on many factors, including whether you have plans to travel and also when your OPT is expiring. But excuse me, in general, if you have an OPT, an unexpired OPT before the start of the filing of your H1, then remember that OPT continues while the duration of your H1. So while your H1 is pending, that OPT will continue. So whatever status you want to be in from April to October, that's depending on that, you should decide to file or not file your OPT. For example, if your OPT has not yet expired as of April 1 and you file on April 1, then you don't need to file an extension of your OPT because there's an automatic extension as per cap. But on the other hand, if you are going to depend on cap, you cannot travel. And if you're going to travel, then it's better to be on OPT status and not on cap status so that you can travel on OPT. So it really depends, I think, on your travel plans, etc. So the facts vary there.
Yes. And also, can they be traveling if their H1B petition was filed before the October of the 2023?
What is the question again?
if let's say that the H1B petition has been approved, sorry, it's H1B petition has been approved, can they travel before the October of 2023?
Right. So as if it's been approved, then there is no change of status application pending. Therefore, you can. It depends on what status you're then on. Most probably, you're still in gap status, etc. So you can continue to be, or you're on your F1 status. So you'll leave and come back on your F1 status, since your H1 really doesn't start until October 1st. So your H1 doesn't kick in. So whatever your underlying status is, that will continue to be your underlying status.
Yes. This other question, under FAQ, it says, if my H1B cap petition is approved, will I need to apply for an H1B visa at a US embassy or consulate abroad?
So if you're in the United States and your H1B petition was approved with a request for change of status, your H1 status will automatically take effect on the start date that you requested in your petition. And for a cap case, the start date would be, for this year, would be October 1, 2023. So there's a seamless transition from your previous status to a H1 on October 1st. So you don't have to leave the country to obtain a H1B visa. However, if you leave the country after October 1st, then in order to re-enter, you'd have to go to the US consulate abroad, get a H1B visa, and then re-enter on a H1. So that's something to keep in mind. You could also go to Canada or Mexico to do that visa revalidation. So there are many ways of doing it.
Yes. Ms. Reddy, I'm sure this is a very common question, but how long can someone be on H1 visa in USA? How long does it last? And also, if for how many more years can they, if let's say they want to, extend their stay, or they are working more, how long can their maximum be extend their stay?
The total duration that a person can stay is on a H1 is 6 years. The initial period of stay would be for 3 years, and then after that they file an extension for another 3 years. And beyond that 6 years period of time, you could file extensions based on certain facts. So if you have an I-140 approved, or then you get a 3-year, you continuously get 3-year extension, so there's no limit until your visa number is not available. So you file an I-140, the next step, it gets approved, the next step is to file a 485. You can only file a 485 once your green card visa number is available, once you look at the visa bulletin to determine that. So if your visa number is not available, then you can continuously file H1 extensions in 3-year increments. The other way you can file is if you have, say, the I-140 is not yet approved, say the labor is pending or the I-140 is pending, then you can get a 1-year extension on your H1, as long as you show that those applications have been pending for at least 365 days. So there are 2 ways of getting an extension: approval of I-140 or pending labor cert or I-140. Approval
Yes.
of I-140, you get 3 years. Pending labor cert, pending I-140, you get 1 year. You can also seek to extend your 6-year limit by making use or recapturing time spent outside the country. So in the last 6 years, you spent 1 month every year in India, you went on vacation. Then you can recapture those, so 1 month in 6 years, so in each year, so 6 months. You would have accumulated 6 months of stay outside the country. So you can recapture that period of time and apply for an extension for 6 months to recapture time spent outside the country. So that's another way of, trying to get a H1 beyond 6 years. Sometimes all that doesn't work out, and there may be a gap between the time that, your I-140 gets approved and the status expires. In such an instance, I guess what you could do is file for a change of status, say to a H4 or to an F1, or though there are challenges to that, and then or leave the country for some time and then come back once you meet the requirements for filing an extension beyond 6 years.
Yes. And also, Ms. Reddy, can we talk about how does transferring of an H1B work?
So basically, transfer means moving from one H1B employer to another. And to be eligible to transfer, you're required to be physically present in the US. And your new employer will need to submit a H1 transfer petition. So in the I-129 form, the petition has to be marked as H1B transfer. Once the new employer submits this I-129 and the rest of the package along with the approved LCA, once USCIS receives it, the person can actually start working for the new employer. They don't have to wait for the petition to actually get approved. So that's one good thing with reference to transfer petitions. Where if you're filing a change of status or a new petition, obviously you can't start working until the petition actually gets approved. But for a transfer petition, you can start working once it has been received by USCIS. But say that transfer petition gets denied, then the beneficiary might be in trouble unless the previous employer is willing to take them back. Say the previous employer withdrew their H1, so they'll be in trouble, then they pretty much fall out of status. So that's something to keep in mind as well.
Yes. So so can one transfer from one cap exempt employer to a cap subject employer?
Yes, you can, but if in order to transfer from cap exempt to cap subject, so let's first understand what is cap exempt and what is cap subject. So cap exempt employer is when you file a H1 and your employer is not subject to the H1B cap. We know that there are certain limited numbers of H1s available, and those numbers open up in March, and they pretty much it's always oversubscribed, so they have a lottery, etc., etc. So if you do not belong to those group of people that has to file a cap subject petition, this can happen if your employer is an educational institution, secondary education institution like a university, or a non-profit research governmental organization, or an organization affiliated to an educational institution like a hospital that is affiliated to a college, like a teaching hospital. In that case, you're not subject to the H1. You can file your H1 at any point of time. But if you would, in the middle of the year, then want to change to a cap subject or an employer that doesn't qualify for that as a educational institution or a non-profit research governmental organization, then you'll have to wait for the cap. And you'll have to wait for your number to be picked. So that's the issue with changing from cap exempt to cap subject.
Yes. And also can one bring their family with them when they're on their H1B visa, Ms. Reddy?
So the H4, which is the dependent for the H1, they have to be either spouses of the primary H1 worker, or they have to be children under 21 years of age in order to qualify as a dependent. And there's a separate visa for this. As I said, that's the H4 non-immigrant classification. They will not need to go through the immigration process, and if it gets approved, then they can live and study in the US. They might also be able to work. So if the dependents are outside the country while you're on a H1 in the country, then all they need to do is book a visa appointment and take all your documents and proof of relationship and request for a visa abroad. And then when they come in, they're given an I-94, which is the H4 I-94. Now, while children can study without any further immigration requirements or petitions, in order for the spouses to work, they have to meet certain criteria. So if the primary spouse has an I-140 approved, then the dependent spouse can file for an employment authorization document, or the EAD. So they file for the Form 765, usually takes a few months to get approved, and then they can start working. So that's So in this instance, some H4 dependents can work while all H4 dependents can study.
Yes. This is my personal question, Ms. Reddy. I had a slight doubt. So people say, I mean, they generally say that if you were born in USA, you are directly considered as a citizen of the country. So let's say someone with H1B had their kid in USA, and what special rights will that kid have? And let's say that the couple is going to move away, or they're going to take the kid with them to India or some other country. Is that like a huge different process that happens?
So if a person born in the US it becomes a US citizen, and no one can take that citizenship away from them. It's very difficult. They can, but it's very difficult. They have to go through Congress to do that. They have to vote. Congress has to vote on it. So it's not easy. Even though Trump tried to do it and tried to change the law, but thankfully that hasn't happened. So a US citizen child will continue to be a US citizen even if that child is not living in the United States but lives in India. But I believe in India, immigration, there are some immigration requirements for India immigration, and you have to report to the police station, etc., etc., unless you take an OCI card. So that's Indian immigration. But from the US point of view, they don't lose their US citizenship because they're not in the country for any period of time.
Yes. Okay. So, Ms. Reddy, let's say that someone's H1B employment is terminated by their employer. What's going to happen, and what's the whole process?
So an employer can at any point of time terminate employment, and there doesn't really have to be a notice period. Different states have different requirements with reference to notice period. And if that happens, then, the employee finds themselves in dire straits. And as per the old law, the employee would immediately fall out of status. But lucky for them, there's a new law now, as per which if the H1 employee gets terminated, that employee has a grace period of 60 days to look for another employer and to file for a transfer. So they have to file a transfer within that 60 days grace period given to them. If they don't, then they have to leave the country or file for a change of status within that 60 days. The 60 days is usually counted from the date of last employment of the employee. If employer is not able to find or doesn't want to find another job, then the employee has to pay for the cost of the return transportation of that employee to their home country. However, if the employee voluntarily resigns, then the employer is not liable for return transportation home, of their employees.
Yes. And also, what does the dual intent mean, Ms. Reddy?
So dual intent means that if you have a dual intent visa, such as a H1, a visa which is not a dual intent is an F1 student visa, or a B2 visa for travel, visitor's visa. So a H1 visa or a dual intent visa means you can pursue a green card while you're under that non-immigrant status. So you can have a dual intent of being a non-immigrant as well as seeking to immigrate to the United States. So that's why people on a H1, most of them file for a green card because they're able to. In order to file for that green card, they file, for adjustment of status, and there's a whole process that takes place. And there has to be an employer that's willing to hire them, and then the employer will have to, if it's employment based, will have to file a labor certification, and then once that gets approved, which could be about a year or so, they'll have to file an I-140, which is an immigrant petition, and then finally, when the visa number becomes available, they'll have to file the green card. And we know that it's a long wait for most people in this scenario. So basically, that's what a dual intent is. You're allowed to have a green card pending, or an I-140 pending, or labor cert, I-485 pending, and still maintain your H1 status. For example, if you file an I-140 so I-140 is the immigrant petition, or even an I-130, which is a family-based immigrant petition, and you're on an F1, and if you leave the country, or you're on a visitor's visa and you leave the country, they won't allow you back if they notice that you have an I-130 or I-140 pending or approved. They may not allow you back into the country. They may not give you a visa if your visa has expired at the consulate, because you have the intent to immigrate. And they can ascertain that intent from the fact that you have an immigrant petition pending or approved. So they will most likely not allow you to enter the country or not give you that visa, because it's very important for an F1 visa and a B2 visa and some other visas not to have the intent to immigrate. So that's what dual intent means.
Yes. And finally, Ms. Reddy, my question is, do the people with H1B visa have to pay for their taxes?
Yes, the H1B visa holder or the H1B worker has to pay taxes the same as anybody else. The terms and conditions are exactly the same. Deductions are exactly the same. So yeah, they get a W-2 and they pay taxes at the end of the year.
Yes. That's it for now, Ms. Reddy. I think we covered most of the FAQs. Let's continue with a different topic next week. Thank you again, Ms. Reddy, for tuning in. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.